Well, welcome everyone to week 4 of OnRamp. We are really lucky today to be joined by Marilou and Chen from Fox Rothschild. They're going to be doing a deep dive into startups' needs when it comes to anything legal. This is a good foundation. You have the right people to ask questions about. Definitely talk about all aspects, whether it's starting your business, protecting your IP. So I think it's gonna be a really great session. And yeah, I expect, questions from the crowd and virtually too. So I will let you take over. So thank you so much.
Good. Thank you, Jessica. And just as a point of clarification, will folks ask questions while we're presenting or at least put them in the chat? So when we come to the Q&A segment, we can just start to field some of those questions.
That sounds great.
Okay, sounds good. Well, thank you so much. And we're really delighted to be here. As Jessica said, I'm Marilou Watson. I'm a partner at the law firm of Fox Rothschild. I'm located in Bluebell. We do have an office right in Center City at 2000 Market Street, but I'm in the Bluebell office. Just a little bit about my background. So my technical degrees are in biology as well as pharmacy. And I did pharmaceutical research for many years and then decided to go to law school. And I'm marrying my 2 degrees by practicing in the area of patent law. And what I will say, what Joe and I will specifically speak about tonight is intellectual property. There are so many aspects, legal aspects to your business that just like physicians are specialized, attorneys are specialized as well. And even within our practice of intellectual property, depending on what our technology specialty is, I use the example of if you needed open heart surgery, you wouldn't go to an orthopedic surgeon to do that work for you, even though that person, she's both a physician and a surgeon. You would go to someone who specializes in those areas. So similarly, in patent practice in particular, you would go to a patent practitioner that is in your technology space of your business. So my space is within pharmaceutics, biology, chemistry, and some biotechnology. So that's my background, and I'll let Joe introduce himself.
Glad to be here. It's always good to be with the highly creative people and the people who put out energy like you guys.
Okay.
So I have a background a little bit diverse. I have a Ph.D. in biology, also a master's degree in computer science, and also another master's degree in chemistry. So I basically, in the day-to-day work, I cover the technical area, including, like facial recognition, artificial intelligence, and also the antibody for treating SARS-CoV-2. So we have written a lot of that application to cover the vaccine and antibody for SARS-CoV-2. And really great to be here today, and we'll hopefully talk about some important IP issue that you start for the startups. And so I think if we don't have a question, we can start.
Yeah, absolutely. And so before we get into the slides, I just want to really kind of preface our discussion with what our experience has been a lot of times with entrepreneurs and startups. And what I like to tell entrepreneurs at the outset is a lot of times what you don't know can and usually does hurt you. And that's why sessions like this, and I think it's amazing that Venture Cafe is, the Science Center is putting on these different types of programs to really educate you, because the things that you need to do very early on in your business are critical. And one thing that I also find, and of course, it's no surprise, every business is looking for capital, right? So you've got these amazing ideas that you want to put forth, but you don't have the money. And I've found a lot of times that entrepreneurs will think, well, I'll kind of get to that IP stuff later. Like, I'll cross that bridge when I get there. Let me be creative and do the things that I need to do to develop whatever new technology or aspects to existing technology. And you forego pursuing the discussions with someone in intellectual property about protecting your ideas, your inventions, and so on. And so some of what we will say in our discussion are going to be scary stories, because I find out that most people remember scary stories. And we just showed off for Halloween, so it's perfect time to have these scary stories. But I'll tell the first scary story. So this relates to a trademark matter. And we'll talk more about the different areas of intellectual property. But someone was referred to me, this was many years ago, and he had an online business and he called it, and I'll just make up a name to not disclose I'll just say it was Cars R Us, where he was selling cars, or I'll just call it Widgets R Us. He was selling widgets online and he used that name and he thought, well, I'm good because this shouldn't have any problem with the Toys R Us, Babies R Us, Kids R Us mark, because this widget has nothing to do with babies, toys, and kids. And so he was doing business for 3 years. So when you have a trademark, what happens while you're utilizing that mark, you're building goodwill. So people start to know you by your mark and your company. So all of a sudden he started making money and he thought, okay, well now I can start to apply for the trademark and kind of lock down these things. And first no was not to do it upfront 3 years prior when he started his business. That was problem number one. Problem number two was he decided to do it himself. And so I'd like to use the example that might be dating myself, but when we were kids, if you had a loose tooth, somebody would tie a string around it, put it on a knob and slam the door and your tooth was out. And so I don't do that. And I don't do this for my kids either. The point is that you go to an expert to take care of that because, I'd go to a dentist because I could be running the risk of getting an infection trying to do it myself. Well, this guy got a serious infection of his intellectual property and hence he had to come to me. He was referred to me because he applied for his own trademarks. And it doesn't mean that you can't do that, right? Because the US trademark and patent laws actually allow individuals and businesses to make their own application. But I have a saying, just because you can do something doesn't mean that you should, right? Make sure you're doing it right. Well, the moment that he files for his trademark, guess what he got? He got a little nasty gram from the attorneys that represented the Jeffrey Company, which was the company that had the RS marks. And what he didn't realize was that in addition to Toys R Us, Kids R Us, Babies R Us, they had a separate trademark only to R Us. And which is a smart move, right? Because you want to police that technology, because if someone comes up with Widgets R Us, and they mistakenly believe that the identity of this company is somehow associated with their company, that's bad business for them. And companies like that really police their marks. So he came to me and I basically told him he was going to have to shut it down. He had to take down his website. He had to come up with another name. And just imagine as an entrepreneur changing your business like that after you've gotten a 3 years worth of momentum and customers to all of a sudden say, I've got to change my name. It's almost like we're under new management. It's just like, is that business going to be as good as it used to be? So I'll just throw that initial scary story out and then we'll get right into our presentation.
Thanks, Marilou. Marilou already mentioned a couple of the IP, type of IP. So there are IP stands for intellectual property. They are can be classified into 4 main areas, right? The first one is patent, generally related to invention. The patent can be a design patent or a utility patent or a claim patent. So the trade secrets are basically anything that's secret that can give you competitive advantage over your competitors, right? Including secret business information, for example, like client contact list, also the proprietary technologies, for example, like secret formula or secret recipe for your products, right? And the other one is a trademarks. Marilou just mentioned that trademark is a goodwill, a branding of your product. And it's a mark that really identify the source of the goods and services of your company. And last one is copyright. Copyright is a registration system to protect the creative expression of your ideas. But in order to get the protection, you have to register your copyright and also to fix your copyright in the tangible medium. For example, if you think about come up a song, you have to record it in the tape or put it in a CD, something like that. There's I want to move that mouse. There's a mouse cover that, right? Yeah.
I have a question. Is
Sure.
it okay to ask questions along the way?
Oh,
Or do you want me? Okay.
Yeah.
So it's possible for a company to have all 4 of those.
Definitely.
Okay, so they're not mutually exclusive.
Exactly.
They can coexist. Okay, all right, got it.
I'm slide for that. Yeah. Good
Yeah.
question.
Oh,
Great
no,
question.
okay.
I just want to mention something again. So Joe, I don't know if you noticed, but one of his examples, for instance, for a trade secret was a bottle of Coca-Cola. I don't know if any of you realize why that bottle of Coca-Cola was there, but whoever came up with the Coca-Cola formula, however many years ago, was brilliant in deciding to keep it as a trade secret, because you would think like no one's been able to reverse engineer Coca-Cola. You can imagine all the colas out there, but they kept it a trade secret instead of filing for a patent at that time on that formulation, because patent terms are limited. So they would have at that time only gotten 17 years. That was back in the day. The term is different now. But think about, I mean, I think that was developed like in the early 30s or 40s or something. And we're, almost 100 years later with that formulation, and no one has been able to recreate that. And one other quick thing I want to mention about copyright, and Joe mentioned something extremely important about fixing an intangible medium. If I don't write down or record or fix what it is that I have created in my creative work, so like for instance, I see with my eye a vision there, right? But until I take a picture of it, using my eye, that's my creative eye to see what's there, take the snapshot. The snapshot is fixing it in a tangible medium. Interesting thing, if any of you ever go to concerts, not so much anymore, but they used to tell you you're not allowed to, record and so on and so forth. The reason that is was, first of all, was to put the world on notice that we own a copyright to the work that you're about to hear. But a lot of times you can imagine creative artists kind of go off script and can start coming up with new stuff. And if they have not fixed it in a tangible medium, they could potentially be leaving their copywritten work as open game. They would have what's called a common law right in it, but it could create other issues. So I just thought I would throw that out there because there's a little more significance to doing that when they tell you not to record concerts and so on.
Yep.
So go ahead.
So first of all, why do we even care about IP? Right? From the macro economy perspective, IP is very important to a nation's economy. Take US as an example. The IP actually accounts for 38% of the US GDP, and the market value of the US intellectual property was about $6.6 trillion. And it also accounts for about 52% of all the US merchandise export. So it's really significant to the US economy. So from the micro economy perspective, IP is also important for any startup, a small company or business, because it really helps to build a market value. So some of you probably at a certain point, you need to attract the investment from VC, right? So the banker and investor want to see that your product are protected, right? So I put a picture of a Shark Tank here because when I have time, I like to watch the Shark Tank with my kids. I always intrigued by the entrepreneur and how they come up with creative idea and products and how they pitch those great ideas and to get investment from the sharks, right? So actually I have a very short video clip from Shark Tank, and this product is called Swap Daddy, and it's a basically cleaning product, right? So we play that video clip.
So it'll.
Okay.
I'm sorry.
Okay.
You can't do it with sound. It'll.
Oh, I can do that. Okay.
Speaker. Yeah, I'm sorry about that.
Oh.
So if you want to just tell what.
Yeah. And let me summarize that video. Basically, he was asked about whether or not he has a patent protection of his product, right? He answered that he has a 1 patent issued and 3 pending. And he has a trademark here, 1 domain name, right? And then eventually he always got a deal and became a very successful business. And actually it's one of the most successful business out of the Shark Tank, right? So apparently this entrepreneur did a really good job. So he has 3 patent applications, 1 trademark, 1 domain name. So like I kind of answer your question, they actually have multiple dimensions of IP protection of his product. That probably, is one of the factors contribute to his success in his business. Right?
It's funny, so a couple of people are saying they love their scrub daddy on that. And that's another important point that Joe's mentioning, because I mean, look, what we are attorneys, and we do our job as an attorney to make sure that we're considering as many aspects and facets of your business. But one of the things that we do, and we have a group, for instance, so Joe and I are with the intellectual property group, but we have a technology and venture finance group to our firm. And these are the folks that get into the deals. And some of them, in fact, sit in Shark Tank-like fashion at like there's not Venture Cafe, I'm thinking that's where we are now. There's like where it's a group where entrepreneurs come out and they try to pitch their business to venture capital firms to see if they'll go for it. And again, at the very beginning, if you don't have these things protected, they'll blank out. That's usually one of the first questions they ask. What's your intellectual property protection on your product? Like before you even go, and it may seem rude and you think you have this great product, but they'll just like, before you start, do you have what you're about to present to us protected, your intellectual property protected? And what do you have? And where have you filed? And what have you filed? And depending on your answer, they'll just like block right out. That's really significant because if you're trying to get money, anyone who's going to invest wants to know that you've crossed every T and dotted every I. And that's why I say that what you don't know and what you don't do up front can really hurt you. You might miss an amazing opportunity to gain some traction with getting support. But here's the other thing that's important, and especially in patent practice, you don't want to disclose your invention without having a patent application on file. That is like patent law 101. And so that's why, you may have heard like, don't tell anybody about what you've invented and so on. And there's truth to that, because once you disclose it in the public domain, in the United States, you have 1 year to get a patent application on file. But there are some countries, depending on what your market is and where you're trying to produce your product, that's an absolute bar. Like Europe, that's it, it's a wrap. The moment you open your mouth and you put your patent your invention out there and you disclose enough of it, you don't even bother to apply in certain other countries. And those are major markets that you might want to go for. And that is something, because sometimes we actually participate as the attorneys in a Shark Tank-like thing. And we're going to ask you those questions. And so that's really important to know.
Yeah, kind of echo what Marilou just said. Actually, about 80% of the startups backed by VC, they actually have patents or patent applications. So pretty high percentage. Yeah.
I have another question. Sorry.
Sure.
I don't know if it's a problem child. So what if it's a service though? So it's not like a technology product. Like if you're inventing a new way to store data, that's one thing. Or if you're inventing, but like if you have a technology service, software as a service, where it's not patentable in any way, shape, or form because it's already out there, then what is it that you need to protect?
That's a very important question. Actually, I have a slide to address that, talking about what invention is patentable. So we can kind of talk about that. So,
I'll be
it's a great question. Yeah.
And Joe's our software guy too. I won't talk software, trust me.
So other benefits of IP, including that it will give you market advantages, and it can help you stop other people from commercializing your idea, and also can deter the knockoff products, and it also can block others from import and export your inventions. And finally, if you have patent, you could be eligible for the Amazon neutral patent evaluation process. If this is some kind of program that Amazon came up with not long ago. Actually, if you have a patent, if somebody sell the product you believe that infringe your patent, you can talk to Amazon. They can initiate that process, help you resolve that dispute. Yeah, it's a really nice program. Yeah, last thing is that IPs also could be an important source of revenue. You can actually get royalties from licensees or damages from infringers. So it's really good. So now we talk about IP a lot. Now, first important part of IP is a patent. So I'm going to talk about patent first. And what is a patent basically? So patent is a government granted right, and for the limited time, is putting other people from making, selling, using, and importing your invention to US in exchange for you to disclose your invention and teach public how to use your invention. So this is a kind of quid pro quo, right? It's an exchange. So it's very important that the US government give you a monopoly for a period of time, but you need to disclose your invention and teach the public how to use your invention. Kind of opposite to trade secret, right? Trade secret you keep as a secret. You don't want to tell anybody about your technology, right? But patent, you have to disclose your invention and teach the public how to use your invention. So, and our founding father actually realized patent is very important for promoting the progress of arts and science. That's why they created the US Constitution under Article 1 and Section 8.
So, and just to piggyback on that, and it's funny because Sean and I had a conversation about this just before we started this. But it's, the reason that these patents have this disclosure of how to make the product that's encompassed in the patent, it's kind of like building a better mousetrap. So you've got a patent to mousetrap, right? But the reason that this exchange, is in place is for everybody else to be able to look at a patent, almost like a recipe, and to follow the steps, and they can create it. But more importantly, it sparks innovation. So if you know what's been created, but there's some new aspect of that someone else hasn't come up with that can make it a better mousetrap, that too may be patentable. So it's kind of like an add-on to it. And so that I just wanted to bring that up because that question did come up earlier.
Mm-hmm. So for the limited time, usually the patent term now is 20 years from the earliest priority date, 20 years, right? It used to be 17 years after issuance. The design patent is basically 15 years after issuance, right? So there are different types of patent. One is a utility patent, design patent, and plant patent. I don't think any of you work on the agriculture, right? So I'm going to mainly talk about utility patent and design patent. So utility patent and design patent, they actually cover different aspects of product. Then utility patent mainly cover the structure and function of the product, and the design patent mainly cover the appearance of the product. Of course, you can file both utility patent and a design patent for the same product, right? And people generally think that utility patent generally have broader coverage for your product. That could be true, but don't underestimate the power of design patent. Design patent have several advantages as well. Usually it's cheaper to file, and also you can get a faster allowance. Basically, you can spend less money, but you can get a patent faster. So it's a nice thing to have. And also you may recall that Apple and Samsung has a lawsuit a few years back, right? Apple sued Samsung for infringement on their design patent. That is the very design patent that Apple rely on. End of the day, Apple got awarded like $500 million for the damages for the infringement of the design patent.
So I just have to say really quickly, when we were looking at the slides and I saw Michael Jackson's patent, it sparked a memory for me because a lot of times I teach high schoolers about intellectual property, and I use that patent as an example by asking a question: who can be an inventor? Because a lot of times kids think that you have to be the scientist and you've got to have all kinds of degrees. And the point in showing them that is that anybody can be an inventor. And so if you've ever seen the video Smooth Criminal, and you see the people that are the dancers and they lean forward and you're like, how in the world are they defying gravity and keeping themselves? What Michael Jackson, he's an inventor on this, amongst others, what he invented was this pair of shoes. And it's really not even just the full, it's partially the full shoe, but it's the heel of the shoe. So if you can imagine a shoe sole, there's a piece that locks into these nails that pop up on the stage that come in and they kind of pop their shoes into the nails that holds them in place. And of course, the rest of the shoe, it looks like a sock with a penny loafer, but it's really like a boot to support your ankles, because if you're going to be bending forward on a 45-degree angle, you don't want to hurt yourself. So the shoes slide into these little protruding nails on the stage, and that allows them to stay in place and lean forward. So that's just like a little side thing. So
that's a very interesting story.
Yeah. I love
Wow.
Yeah.
Back to the last slide though, is there a patent on avocado?
Well, there's certain strain. They probably can come up with a particular
Well, you
genetic
think
version.
and if you think about hybrid flowers
Yeah.
and stuff, oh, believe me, there are lots of hybrid things we eat these days.
Exactly. So this slide basically show you that you can file both design patent application or utility patent application for the same product. This product is called a Squatty Potty. You probably seen that in the Best Buy Beyond or Home Depot sale about $20. And that product actually was also pitched in Shark Tank as well. Now it's also pretty successful business story. So.
And just the difference, sorry.
Okay.
Are you able to do that? Because
The sound will
the
reverb.
sound will
No sound,
reverb,
yeah,
okay.
yeah.
But just with respect to the squatty potty thing too, and you may think like, well, wait, they look the same and so on. So a design patent only covers the ornamentality of an item that you're patenting. The example I tend to use, so they look the same, right? But one was the design, and you may be like, well, what's the difference with the utility part? So what's the usefulness? Utility usually stands for usefulness. What's the usefulness of this? Like, what's the functionality of it, right? As opposed to the design, the way it looks. So if you look at that squatty potty, the utility one had like the rubberized pieces on there. Like there may be aspects of it that allow it to be more stabilized as opposed to just what it looks like. And one of my examples that I use as the difference between a design and a utility. So 4 salt and pepper shakers were made. So once somebody first came up with a salt and pepper shaker, that they could file a utility patent on a device that allows you to dispense condiments, whether, you pick whatever you want. And so that is the utility of it. It is a device that allows you to dispense condiments as you need it, right? But a design of it is, what if you had a salt and pepper shaker, one was like the Statue of Liberty and the other one was the Eiffel Tower. Well, the design of it is what you would get the patent on the salt and pepper shaker, the thing that has utility, but you could not, apply for the utility of the design aspect of it. Does that make sense?
Yeah.
Yeah, and there was a question in the chat saying that there's a lot of knockoffs on the squatty potty. I'm just wondering how the patent protected the inventor, which I think you're kind of getting at in terms of, the add-ons to that.
Yeah, I quickly mentioned that even though they filed both design patent and utility patent, they probably, end of the day, they did not get utility patent issued because the product itself is relatively simple, right? It don't have many components, doesn't have a complicated structure. Therefore, they couldn't get a utility patent, but they did get the design patent application allowed. But again, the design patent application is based on a quite different, standard to determine whether or not somebody infringe your product. If the other knockoff product is a little bit different, then sometimes they do not infringe your product, your design patent. So it's case by case analysis, depends on how close. If they're really close, they could infringe your design patent. But if ordinary observer determine that they are a little bit different, then they may not infringe the design patent. So it has to analyze based on case by case.
Yeah, and as I told someone previously, the typical lawyer answer is, when you ask a question like that, it depends. And I know sometimes it seems like lawyers are trying to be squirrely by saying, it depends, but it really does. It's very fact specific, and it depends on what's already out there. Joe said earlier on that a patent has to be, new or novel, not obvious. And so when you talk about the non-obviousness piece, you have to look at what's already been out there, what's already been created, and whether someone skilled in the art of making step stools would have said, yeah, this would have been obvious to add a little rubberized piece for it so you don't slip. That's what a step stool is for, to step up and not slip, like different things. And so that goes to the non-obviousness piece, and it looks like you were going to go right into that.
There are some baseline requirements in order for you to get your invention patented, right? So we're not ask whether your invention is patentable. So first thing is whether you conceive the idea actually reduce to practice. Cannot only be idea in your brain, you have to reduce it into writing the list, or ideally if you have some prototype, even better, right? So the second is has to be new, not other people already come up there saying, or even yourself can be prior. For example, if you disclose your invention before filing a patent application, so your disclosure could be the prior to your own patent application. So don't do that, and then we can talk detail about that. So it also has to be non-obvious. What does that mean, right? So it has to be not a obvious modification, improvement, or combination of what already known. For example, if you take a hamburger and make it bigger, you put more layers into it. probably would be considered as an obvious modification, right? It's not inventive enough, right? Probably is not patentable. But if you combine a camera with a traditional form, a flip form, you get a smarter form, which could be non-obvious, can be patentable. Obviously, there's a patent for that. So last thing is that your invention must not be a patent ineligible subject matter. For example, it cannot be an abstract idea, cannot be a law or product of nature or the nature phenomenon. For example, Einstein's famous relativity equation, like E equal to mc squared, that's not patentable because a law of nature. It's not patentable. Right? So going back to your question about the certain method of providing services, right? So it depends. It also depends. My standard answer without knowing more details that, and sometimes certain process can be considered as an abstract idea. So you need to have a lot more non-conventional stuff, steps in your process in order to get to put your idea into a non-abstract idea category.
Got it.
Something else I want everyone to make sure that you're aware of, especially as entrepreneurs, because people get kind of tripped up on this. So say, for instance, like, Joe said, you just can't patent an idea just because you came up with something. But an example I use is, so for instance, say one day I said, you know what, it would be great to have a jacket that could make me fly, right? And okay, that's an idea. It might be a great idea. I haven't seen anything like that before. It's not obvious, but I don't know how to make that jacket, right? And so what happens? So it's just an idea. So I can't just go around patenting something that's a really good idea because I don't see it somewhere, right? But say I take it a step further, and it's like, well, you know what? I think this can really be done, but I don't know how to do it. So let me go hire an engineer. So this happens a lot of times with startup companies. You go outside and you go to consultants that are specialized in whatever area you need them to be. You engage them to help you really bring your invention into full effect, right? So say you're an engineer and I come up with this idea, I come to you and I say, well, I have this, and you look at it and you go, yeah, well, if you add this and a little jetpack there, and you want one on the side, not in the back, so you don't burn your hiney, like trying to go up in the air kind of thing. And you have actually added to that invention. Guess what? Even if you're an independent consultant, you're an inventor, and you must be named as an inventor on that patent application, or you run the risk of that application being invalid. And I've come into contact with situations like that where startup companies have hired outside consultants and thought, well, I paid you already, and you don't have any, you gave me what I needed, and thanks a lot, see you later, I'll call you next time I invent something. You can't do that, because if that person added to that inventive concept to enable it, what we call enable it, to make it work, that person must be listed as an inventor. So I think I wanted to particularly point that out, because you can really jam yourself up if you don't list the appropriate inventors on a patent application. So
Quick question.
No, I should say quick question to that. So if, even though they are listed as an inventor, is the IP assignable in any way?
yes, sorry, Andy. I should have totally have gone that next step. So because then you would worry oh my gosh, because in US law, in particular, the owner of a patent or patent application is the inventor, right? And then Joe will talk a little bit later about assignments and things like that. So the thing you want to do is that if I'm going to hire you as a consultant, I better have an agreement in place with you first. First of all, I need to have a non-disclosure agreement in place with you. Everybody needs to write that down, because if I start talking to you about my invention and there's not an NDA or a CDA, confidential disclosure, a non-disclosure agreement in place, I'm effectively putting it out in the public domain, because you have no obligation to keep it to yourself, right? And then I start to kind of mess myself up with my time bar running, right? So first you want to have an NDA or CDA in place. And I always tell people, blame it on your attorneys. If someone's like, oh, I don't want to sign a CDA, they're like, listen, my attorneys are paying the neck. They're telling me I have to do this or I can't talk to you, So that's the first thing. Secondly, you better have an agreement in place with that consultant where the consultant agrees to assign his or her aspect of the invention back to you and your company. Because, it's not just, oh, I paid this person to do this for me and now I own it. Because again, under patent law, you have to list all of the inventors. And so, yes, you're absolutely right. And so that's a contract. that I would, that's a contractual issue. And I would have you sign that you will grant your right back to me through an assignment. And then that gives me right to pursue you in court if you don't do it. So that was an excellent
Can
question.
you sign away an ID you haven't had yet?
Well, yeah, you can't sign away an ID you haven't had yet. But I think the point that Andy was making is if Andy was the engineer that I went to, he's an inventor. And so now I would want to make sure, your company would want to make sure that you get everyone that is involved as an inventor to assign their right to what has been created and what exists. You don't do it, what you do is I understand what you're saying. So what I would write in that agreement is if Andy adds to my invention and he ends up being an inventor, he has an obligation to assign his right to me, even though he hasn't started working on the project yet. So I think that's what you were saying. How do you assign a right to what hasn't been invented yet? And so what it is it's an agreement that I'm hiring you to do this work. And you are also agreeing that whatever you develop from this that's applied to my product and my concept, you're going to assign it to me and my company. So I'm sorry, Sean, you had a question?
Yeah, is an employee automatically assigned?
Yeah, excellent questions. They should be. Another thing to note, when you have a company and you're starting a company, one other aspect aside from intellectual property specifically is employment law, right? So many of you, if you have a job and you work for a company, you probably didn't even pay attention, but in your agreement with the company, there's usually something, a little blurb in there that's an intellectual property clause. And it doesn't matter what you do. You could be the janitor for the company. They become standard because what happens if when you're on your job, you discover something, it has to be clear in that agreement that what you discover as a part of your normal course of business in your job belongs to the company. It's what I call the but-for rule. But for you working for my company, you wouldn't have had the opportunity to discover what you discovered in the lab. And so that just makes it, that should make it clear. Now, I've actually had people come to me, and one of the first questions I ask is, who's your employer? And does this have anything to do with what you do for a living? So if a chemist comes to me and says, I came up with a new toy to do this, or I came up with a new car seat. If their employer doesn't do car seats, arguably that has nothing to do with the intellectual property or the aspect of what the company's inventing. And that's something that would be carved out of that clause. But we have very clear and specific conversations with potential inventors that come to us who say they've come up with a separate idea, because we need to be sure that it is really separate. Because that employer can come after them later and say, hey, no, you invented that because you had access to my labs and that kind of thing. So that's an excellent question, but most employers will make you sign an employment agreement that has an intellectual property clause.
What happens if all of the employee agreements and all the NDAs have been, kind of lost to the sands of time?
They usually don't. Because, I mean, it's while you're employed, right? So it's like, this is what you agreed to while you're employed. And then usually you should have, you make sure you come to us to make sure you write really great intellectual property clauses to these agreements, because one issue that can happen is you're an employee with my company right now, you leave and you go to Andy's company, and Andy's one of my competitors, right? So I want to be sure that in my employment agreement, I'm writing something in there that makes it pretty clear. And usually I have, what do you call it, in the military where they debrief you. We have a debriefing before you leave, an exit interview, whatever you want to call it. And it's usually during that debriefing or that exit interview that we remind you of what is ours, and to make sure, because guess what, if you're an inventor, you can't extract what's in your head.
Well, what if the employer has gone bankrupt?
Okay, so we can, in the interest of time, I'm gonna give you the typical lawyer's answer. It depends. And I will say this to all of you, if any of you have specific questions about any scenario that you're familiar with, please feel free to reach out to me or Joe. And we usually offer like an initial discussion gratis, and especially mention that you met us here or you engaged us here. I mean, you engaged us in a discussion here about that, and we're happy to have a follow-on conversation, just in the interest of time. So
Thank you.
All right. So you want to file a patent application, what option do you have? So the first one is a US provisional application. US provisional application actually is really nice because you basically hold your hold your case for 12 months, right? So say, because US patent system now is a first to file, so it's very important to file early, right? But you don't want to spend lots of money on filing a patent, so you can file a provisional application. Provisional application, the government filing fee is about $75. Of course, you need to pay attorney fees to drop the patent, but it's relatively cheaper to file a provisional application. And but the application is not published and examined. So if you feel like you don't want to convert that provisional application into a non-provisional application within a year, then you can abandon it. You can file a new one, right? So that gives you some option there. Of course, if you want to have a IP protection as soon as possible, you can file a non-provisional application directly. Usually, US PTO examiner will pick it up within 1 or 2 years, and then they will examine your application to determine whether or not your patent, your invention has a merit to be patented or not, right? And of course, if you want it even faster, to get the patent, you can pay the fast track. You can pay extra money, a few $1,000s to get the patent issuance as soon as possible, right? Say you want to eventually market your product in a foreign country, you may consider file a foreign patent application. There are 2 ways to do that. Say you want to enter, Europe, China, or Japan, you can file the individual foreign patent application in those countries, right? But there's a better way to do that. You can actually file a Pct International application. So that will hold your space, hold your place for 30 months since from the earliest priority date for 30 months in the 150 countries. So you can defer your expense, right? Because sometimes you're not sure whether your invention will mature into a good product, but you don't want to spend lots of money into it. You can file a PCT, right? It gives you 2.5 years, 30 months. Then you can decide whether or not you want to enter certain countries, right? So it's a really good vehicle for you to file the international patent application.
And venture capitalists want to see that you've done something like
Yeah.
that. Because, at the beginning of your business, you need to decide what your end goal and end game is with your business. Am I getting into this to sell what I have to XYZ company, or am I looking to do this for the long term? But at the very beginning, if you have an international application pending, and you've got whatever 2 years, 2.5 years from whatever time you start talking to VCs, that tells them that they have the option of this can blow up into something bigger in a larger marketplace around the world for much less cost than if you go into the individual countries. But if you don't have it, a lot of times it's just like, nah, it's okay. Well, like, oh, we only can go into the US market. That's all you did. You missed that filing date to file it internationally. And now instead of our pie being this big, now it's just this big. And it still could be important, but I usually recommend that you consider an international application.
Yeah.
You have a question?
Yeah, I was just wanting to make sure, so like this application process are only kind of like for companies that are like very unique, or is this for
Everybody,
Okay.
everybody. That's a good question though.
Yeah.
Because a lot of times people think you have to have some kind of extra special something. If you have a patent application filed in the US, you have the ability to file internationally for that.
Yeah. So for starters, I also want to talk about the patent filing strategy, right? So as I mentioned that US patent system is the first to file. Actually, most of the world actually is the first to file, right? So you had a file to win, right? If you're the first person to file for the same invention, you can block other people later file people, right? And then you also want to make sure you keep your invention confidential before. We keep saying that because it's very important, right? If you disclose your invention before patent filing, then you kind of screw up. You probably still okay for US for some situation, but not for the other countries, right? And also, if you don't have a lot of budget for IP, you could file a provisional application to defer the cost, right? Because provisional application is really a placeholder and give you also cheaper to file, right? And you can also file multiple provisional application because your R&D process progress, you may have new discoveries, and then you feel the need to file new application. So you can file multiple provisional application, right? Again, Yeah, that's why we keep saying that, right? Pre-patent disclosure are really risky, right? Because disclosure is really broad, right? It can be in the print, can be in the marketing brochure, can be website, can be research paper. It can be on sale. If you have even a secret sale, right? Confidential sale can be viewed as a disclosure, and also any other means. For example, you put on YouTube, Instagram, or trade show, it can be a disclosure.
We have a question from online asking that if you create a curriculum or a course to teach a skill or methodology, is that something to file a patent, trademark, copyright, or trade secret, or a combo of any of the above?
Yeah, that's a very good question. So I need to, again, for the patent, is actually, there's a baseline requirement to evaluate, right? You have to meet, first had to be patent eligible, right? Second, it has to be new and non-obvious, right? I don't know, without seeing the curriculum thing now, I don't know how novel, how new, and how non-obvious that is, and we don't know whether or not it's patentable until we kind of evaluate that, right? Also, for the curriculum plan, it could fall in the copyright category if you have a particular design of that plan, and that can be protected by copyright, right? So that's something you can consider. Yeah.
And it could be protected by trademark if you decide to call your curriculum the ABC curriculum, whatever it is you call it. So it could apply, or the trade secret aspect. So there's some things, understand that if you file a copyright with the Library of Congress, which is the authority that you file copyrights with, it becomes publicly available. So if it's a curriculum you don't want to be publicly available, you might want to keep it to yourself, which would make it a trade secret. And I've run into that with companies that have created, SOPs and stuff for certain things. And they have this like state-of-the-art way that they handle certain things. Yeah, sure, you can file a copyright, but once you do, everybody else that wants to go to Library of Congress can go find your SOP and apply it, and you may have a hard time kind of proving that they're infringing on your copyright. So it's just something to think about.
Yeah, I saw somebody asking about the budget, right? So that's a pretty tricky question, right? It really depends on.
Call us.
Yeah, it depends on invention, right? So for the copyright, actually, you want to register a copyright only costs less than $100, right? And take about 3 or 4 months to get your work to be copyright registered, right? For the patent, it really depends on the subject matter. If you have a pharmaceutical invention and a biological invention, it's very different from the software invention. So it's everywhere. It's very difficult to give you a exact number. And for the trade secret, of course, you just need a lock. Just lock your secret in the box.
How can trade secrets be transferred or shared? I take the Coke example right? So somebody at some point has to punch that formula into something, or their procurement has to know, right?
Yeah.
I mean, it has to be able to be shared within the company. So to what degree can it be shared?
So it's my understanding, and don't quote me, that in the Coca-Cola company, only 3 people have access to different aspects of the formula. So none of those people come together to your point.
Yeah.
It has to be something that's truly policed.
Yeah.
And you as a company have to be very proactive in your thought process about how do you protect this. And that's why people get sued for trade secret infringement, because if you work for a company and you know their secret sauce and what they do, and you go and sell it, well, you've just infringed, and you've just disclosed our trade secret, you're in a lot of trouble and you'll get sued. And usually the company that buys it from you is going to go down too. So
I kind of jump ahead of my slides because Andy asked this question about trade secret. Basically, you may come into a situation where you need to decide whether or not you need to file a patent application for your technology or keep it a secret, right? So there are a few things you may want to consider, right? First, you need to determine whether or not your technology is even patent eligible or not. If your technology is not even patentable or patent eligible, then only thing you can do is keep it secret, right? You cannot patent it, right? Number 2 is that whether or not your technology can be reverse engineered, right? If somebody can easily reverse engineer your technology, then better file a patent, because you can't keep it secret because people can reverse engineer it. Like Coca-Cola formula is difficult to reverse engineer. Even you can reverse engineer based on now there are tons of modern technology can probably figure out the ingredients, how much ingredient they use in the formula, right? But they have brand name, right? They have trademark, right? If you put the same recipe in a different bottle, people don't buy it. So,
Yeah, could you then patent Coca-Cola's recipe and then exclude Coca-Cola from using their recipe?
well, then probably it's too old to. to
Right,
be
well, not
patented.
only that, it's already actually been out there
Yeah,
too,
too old,
so
yeah.
there are
It
whole
hasn't
other.
been disclosed.
But there are whole other aspects of intellectual property law that if it's already been utilized out there, there are other more esoteric arguments to that is a lot to get into, you know, when you're given the broad brush, but they're excellent questions.
Yeah.
Because that means that you're thinking about all the things you should be thinking about as entrepreneurs as you go through this process.
Yeah. Next question Andy asked is that, you know, if you want to license out your invention, right? So you may want to file a patent because as a trade secret, it's probably not suitable to license to another people because you have to tell them what it is, right? So unless you, Coca-Cola, you give people a concentrate, Coke, dilute it, add water to it. So where am I? Okay, now as I'm in the disclosure part, right? So it's critical, especially if for the foreign filing, right? In the other, you know, in US patent system is a little bit more forgiving. So if you happen to disclose your invention, you have 1 year grace period, right? You can still file patent application to protect it. But other countries not so forgiving. If you happen to accidentally disclose it, that's it. So you basically lose that right to file a patent on that technology. So be very careful.
So how do universities ever publish papers? Like, it seems like they wouldn't let any of their students. ever
Yeah,
publish.
they should be reviewed by an intellectual property group to be sure that you're not putting something out there that should be at least filed in a patent application first before it gets published. And that is something that we deal with a lot with university clients. I was going to suggest, in light of the time, if you want, maybe we can go into trademarks and copyright.
Sure.
And well, so you've already covered patents and then trade secrets.
So that this slide probably go over very quickly because this is a practical kind of tips, right? So first one is make sure you file a patent to cover your key products. Because if you want to launch your product, you better make sure you have IP to protect that. And also you need to do the pre-marketing clearance. You want to make sure your product is not covered by other people's patent because you don't want to infringe other people's patent. So if you need to get a license, you want to get a designer, try to design a one, you need to do that. Also, you need to monitor the IP of the close competitors, right? So the last thing is related to inventorship, right? So you make sure the entire team assign the IP rights. Okay, this probably needs to be assigned even before you form such, you know, employment relationship. When you hire them, you get them to sign that agreement, because when you fire them, it's difficult to get them to sign anything, right? So you better to have them sign when they start to work for your company.
And the actual inventors must be listed on a patent application. Run into this situation before where the CEO of a company says, I'm the CEO, put me on the patent. That's a no-no. Unless that CEO contributed to the inventive step of what's in that patent application, you have, you run the risk of invalidating your patent application and your patent if it gets issued. And we've run into that as well. So just be mindful that you need to make sure that whoever has invented the claims in your invention are actually listed, but we'll keep moving on so we can.
Next, we're going to talk about the second area of IP is a trade secret. We already talked a little bit about that already. So one important thing is to make sure you take steps to keep it secret, right? If you don't take any guard, your guard a secret, then everybody knows the secret, it won't be a trade secret, right? So you have to, perhaps physically, lock your secret in a cabinet somewhere, and also confine the knowledge in a small group, only based on the need to know basis, right? Don't tell if everybody in the company knows it, probably it's not a trade secret anymore, right? And also the trade secret has a pretty long, like a lifespan, just like Coca-Cola actually keep that trade secret more than 100 years. As long as you keep a secret, it can last forever. Not like a patent. Usually it's 20 years, from the priority date. So these are a few examples of trade secret. Right? We already talked about Coca-Cola and the KFC fried chicken. Actually, is also their recipes are kept as a trade secret. They have 11 herbs and spices in the fried chicken, and also the lubricant, the WD-40 and the Listerine, the mouthwashes also, they keep the recipe as a trade secret, right? So we already talked about this slide. Now I'm going to shift gear to trademarks. Trademark again is a marks identify the source of the goods and services. Basically, it's a way you distinguish your products from other people's products, right? So the right comes from actual use in commerce, but you can apply based on the intent to use basis. So even you don't have product in market, you can still apply for it based on your intent to use. And it's very important because it can prevent other people from using the similar marks, right? Confusingly similar mark on related goods or services, right? So also it can last forever if you continuously use that mark, right? So there are a few examples of famous mark. I put a Meta there because I just saw that Facebook just recently raises a Meta mark out of Facebook. Yeah. So there are a few non-traditional mark that trade dress basically protect the unique design of the product, the shape or the appearance of the product, and color and the sounds sometimes can be also protected under trademark. So trademark also has a mechanism for you to register with the US Trademark Office. So it's important to get a federal registration of your mark. So it basically gives you a national priority date. This is important because if you register earlier, you can block other people from registering similar mark or same mark, right? So it also very importantly is like also give you a presumption of validity and also incontestability out of 5 years of continuous use. This is very important because if you don't have a federal registration, you try to bring an action against the infringer, you have to prove that your mark is valid, right? How do you prove it? You have to do the consumer survey, right? To show that consumer was able to associate a mark with your product. And that's very costly, right? So if you have federal registration, you can shift that burden to your infringer. Infringer has to prove that your mark is invalid. So you basically shift that costly burden to infringer. So it's very important, right? And also, after you register mark, you can put an R out of your trademark. If you don't register, you can only put a TM stands for trademark, and SM stands for the service mark, right?
And just so you know, it's fraudulent to put the R in the circle and you don't have a registered mark. I've seen people do that, and I would look it up real quick and go, do you realize you don't have a registration on this? Better get rid of that R in the circle and put the superscript TM or SM for trademark or service mark.
Yeah. So
I have a quick question. So if somebody applies for a trademark and their business never takes off, like what is the grace period by which then it becomes, because it goes into this database, right?
Yeah, right. There's a period of time, you're saying if they get a registered mark, because there's a period of time that you have to continue to prove that you're still utilizing this mark and so on. That you don't want to lock down this mark and you're not using it, more or less. So there are periods of time that you're given to renew your registration. If you don't renew your registration, then it's up for grabs.
Okay, and what are those periods of time?
So it's like, I think it's like 5 and 8 years. Like, I know enough to be dangerous in the trademark space when it comes down to but it's like 5 and 8 years.
Okay, so it's not like 6 months.
So
It's long, yeah, okay.
So if something's abandoned, you can technically use that.
Absolutely.
Yeah, I guess that's what I'm
Absolutely.
asking.
And the other quick last point I want to make about this too, is that a lot of times people think that you can have the same mark and more than one person or company can get a registration to the same mark, but for different goods and services.
Yeah.
So for instance, and I use this example, if I make a red vacuum cleaner and I want to call that vacuum cleaner an Apple, and I want to register the mark Apple, but for vacuum cleaners, and we won't get to the splitting of hairs and, well, they're computer vacuum cleaners. No, I'm talking about the kind, like, just for purposes of the example. I could still get a registered trademark to the term Apple, as it relates to my goods or services
Got it.
versus like, you know, the Apple company with computers and everything.
Yeah.
So I just wanted to throw that out there.
Yeah, actually related to Maril's point, actually, I picture there is a both product called waffles, right? One is a KFC's hamburger, right, waffle. The other is a Hershey's waffle milky chocolate, right? They are two very different food products, right? Therefore, even if they are called the same name, they are not confusing.
Right.
They are still okay to use the same name, waffles. And but if you have a Starbucks logo like that, and then you have something called Star Prius, and there's also coffee. They are basically the same type of product that can be confusing. Yeah, that can be.
Yeah, got it.
Yeah. So I think that this slide I want to mention is very important to run a trademark clearance search if you decide to choose a mark, right? You don't want to end of the day, you spend lots of money and time on a mark that and spend tons of resources doing a PR campaign and then realize that mark is not, you cannot use it. And other people is already registered. That's a pretty bad situation. So make sure you do as a first step, you do the clearance search, right?
And can I do that, or does an attorney have to do that?
I would not, some people do it themselves, but it's you're not skilled enough. And I don't say that to say that, you know, you don't, but there are things that we search and databases that we search. And there's actually even a company that if you, depending on how big this product is and how important it is, we say, look, you don't have to do it. But if this thing is about to blow up, you want to make sure that you've crossed every T, looked under every stone. And there are actually companies that do nothing but these searches. And we will hire those companies, and whatever cost they charge, we just pass it through. We don't attack on any cost.
Got it.
But
Okay.
yeah, so they're
it's a
different levels.
sophisticated search.
Yes.
It's not like you just look up one
Yeah,
word and
yeah.
something or another.
Okay. I paint, I don't know if it's like painting. If I sell my art to someone else, do they have the?
So that's copyright, because you're using your talent and creativity of your artistic talent, you're fixing it into a tangible medium, whether it's on a canvas or a computer, whatever it may be. So you would get a copyright, and you would have immediate common law copyright rights in it. What you want to do is file that with the Library of Congress, because if somebody takes your painting and suggests that somebody like print out your painting, we actually had this happen where somebody was, a painter had registered her copyright with the Library of Congress and came across a blog one day, and someone was saying like, well, you know, if you're feeling down, why don't you, you should probably get a picture that has these beautiful colors that can make you feel more calm. For example, here's one, blip, and they had taken a snapshot or an excerpt of somebody's painting off of their website and dropped it in the blog and said, just print this out and put it in a frame and stick it on your desk and look at it, and the colors are nice and calm. We're just like, are you kidding? And it says like copyright infringement 101, and we were able to send her a cease and desist and make them take the whole thing down because she had a registered copyright. The difference between a registered one versus a non-registered one is, like I said, as soon as you paint it, you have a copyright in common law. The problem is that you cannot collect damages for someone who has infringed your work until you have a registered mark. So that's really the big difference between it. And so that's something to keep in mind.
Yeah.
Well, if I sell my painting to someone else.
Oh, it belongs to them. I
then they have
mean,
the copyright then?
what you're doing is you're selling the work of art in and of itself. And so the copyright would go along with that work, because you're selling that piece of work. And the other thing too is that there could be a work for hire. Right. And so that we would also argue, if you were saying like, oh, I own that or whatever, again, it depends, right? So if you sell numbered series of the same work or whatever, you're selling the different numbers of those series. But if I hire you to paint something, okay, I want you to paint my portrait, that's a work for hire. And so that in that agreement, and you would want that agreement in place, that I would own the copyright to that.
Okay.
But it's usually understood that if it's something being painted specifically for someone or for a purchaser, that it belongs to them.
Including the copyright.
Right.
Yeah, since we already talked about copyright, so there are a few benefits of the federal registration. Marilou already mentioned that the good thing is that it's relatively inexpensive to get your work registered, right? It costs less than $100. I believe it's somewhere like $75 to get your work registered, right? And take about 3 to 4 months to get the registration process, right? And another good thing is that if the infringement happened after your registration, you're probably entitled to statutory damage
Right.
and attorney fees to enforce your rights, which is a good thing. You don't want to.
Right.
Yeah.
But it has to be, it's from the date that you filed your registration.
Right.
Even and up until you get the registration, you know, we want that process to be in place
Yeah.
to collect damages.
So a little bit summary. So we have been talking about the ownership of IP. Again, we previously talked about the patent was initially owned by inventors before they assigned to a third party or to the company. So therefore, it's important to make sure all your employees assign their rights to the company, or at least have an obligation to assign their rights to the company, right? And the copyright is also originally owned by creators unless they are created under the work for hire agreement, right? And also, of course, it's a little bit tricky when the work is created by consultant or contractor or pre-company funders. So, so it's important to have, you know, various types of agreement to secure your IP. So you can have a non-disclosure, non-use, non-complement NDA, those agreement to make sure the IP is protected, and also make sure the assignment of invention is in place. And also you need to make sure you have work for hire clause in the employment agreement. And lastly, you want to make sure they sign the agreement when they start to work for your company. Yeah.
We have a question online. Is there time for a question?
I think so.
So this comes, so they asked, a friend has a trademark for her company name in the US market. Due to family issues, she forgot to renew the domain name and someone bought it and is now trying to sell it. This was bought and trying to sell under bad faith. Can the trademark owner reclaim the domain, and what is the process? What are the grounds to be used for such a claim?
That probably is a very specific.
It
question, right?
is, it
Yeah.
really is,
Yeah.
because
Yeah.
it really depends. There are like 1,000 questions I could think
Right.
of to ask. And so that's
Yeah.
something, you know, if you want to reach out again, we could get, especially one of our colleagues that works in the area of domain names and things like
Yeah.
that, and trademarks in particular. But that is a really specific question. And then again, it depends. We're really giving you broad brush information for you to understand that, you know, like in law school, they teach you to spot issues. And we're just trying to provide you with information. So you do have these great questions that you've been asking, like, is this an issue? Is that an issue? And that's when you should go seek counsel to make sure that you're addressing it properly.
Yeah. Lastly, I have 2 slides basically say what not to do and what to do, right? So I think I want to skip reading that. So I think we'll leave the time for Q&A. If you have additional questions, we're happy to answer. You will get. Yeah.
I think Steve has a question.
Yeah.
Go ahead.
So as far as data and say like scraping other websites, I know that's probably still being determined, but what are the potential risks of doing that?
I guess your question is about database, whether or not database is
Yeah.
protectable.
Well, I guess even to give you a more specific example, if I'm taking information off of say Glassdoor and using that to power some algorithm, am I kosher?
Data. Also depends, right? Generally speaking, the database in US is not protectable, not like EP. In Europe, actually, database is protectable, right? So putting out data, I mean, sometimes certain website, they have a limitation. They tell you, not to, pull the data out, right? Don't use the web crawler to pull the data. Then you cannot do that, right? Because they have a then notice on the website on that, and sometimes they do not. And I think if you have to check with them before you pulling mass amount of data out of their servers. Yeah. For example, I personally know, USPTO, sometimes they don't want people to put, vast amount of data out of their server, because one thing is you could slow down their server, right? Because you basically occupy the resources, and other people cannot visit the site very well. So, and then they usually limit that vast data pooling, right? And really depends on the website. But again, the database is not protectable in US. Yeah.
And I'll just say, I stay in my lane, software person. I saw somebody had a question up there. thanking me and Joe for anything software, like biotech, pharma, and he does some of that as well. But that's why Steve was looking at me and I was like, look at Joe. Look at Joe, Steve.
Software is very tricky kind of category. I know some of you guys are from software, kind of field, right? So I have a quick slide to show you, so in the US, right? So there are several categories that, the law says you could, get a patent for it. For example, like a process, Amazon's a one-click method, is patented, and the price line, hotel auction method is patented, right? And machine, some of the machine is also like internal combustion, the machine is patentable, and some of the gadget devices and some genes, right? But it cannot be genes take out from your body. It has to be, synthetic genetics, cDNA, is what I mean. And also the recombinant genes could be patentable, right? So, and software is not one of them, right? But sometimes software can be put into some kind of like a process or method kind of category, depending on how you treat it. And also, over time, the USPTO will reject the software as an abstract idea. So you have to, that's why you need to consult with an attorney and figure out how to kind of move that software out of that abstract idea bucket. Make sure your software is patentable. It's not automatically patentable because Congress did not create a category for software yet. We hope that will happen. That will happen one day. Cool.
There's a question online, kind of tying into the art discussion we were having earlier and also online. Someone wondering about how to protect published columns or things they produced online. Do they have to be on your own website? Or if they're published elsewhere, like how does that copyright work?
When you say published columns, you're talking about like written, like you're writing an article. Is that what you mean by columns?
I would imagine.
Yeah, because when I saw that and I thought, that could be a software kind of code. I don't know, is there a column in software? Okay, so I'm sorry, repeat that. So if they're published columns, well, first of all, if you're the author of the column, you have common law rights in that authorship. However, columns of ideas and analysis. So you're saying like you're writing your information down, you're providing information. So if you are, let's stick with the basics to make sure that we follow along the right line. So if you are writing the content of an article, of a column, and so on, you are the creator of that content. Now you might work for a company that pays you to do that. And again, that's when you would look at your employment agreement to indicate that anything that you write or create usually will typically belong to the company. I'm not sure if that helps any, and I've had something similar happen where there was a physician at a local hospital who created a survey. I'm an IC, so it belongs to me. An independent contract, I'm assuming. Okay, yeah. So I was like, I'm like, these codes, like, you start talking about software and everything, every acronym I see is like, that's a software code or something, Joe. But anyway, so for instance, there was a physician at a local hospital that created a survey that helped determine maybe like what patients might have a higher propensity to, I don't know, have a cardiac arrest or something like that. I'm just making it up. And, but he was employed by the hospital and he signed an employment agreement because he was leaving to go to a hospital in Chicago. So he came to me and wanted to know, like, can I just take my survey stuff? And I was like, whoa, let's see your employment agreement. And sure enough, there was a clause in there that said that basically that the hospital owned any IP you created, which would include the survey. And a lot of times too, again, it depends. So I said, well, listen, everything doesn't have to be contentious. The hospital may see this as a useful tool and may want to continue to use it. And so you just talk to them and say, look, I created this. I want to use this wherever I go. Can you grant me the ability to utilize my survey? Because I'm going to this hospital in Chicago, arguably a competitor, maybe yes, maybe no, in the cardiac space. But they ended up saying, sure, you can go ahead and do that. But you have to give us, you'll give us a non-exclusive royalty-free license to use this over here and in any way we want. So I'm not really sure if I'm answering your question or not with that example. And again, you can feel free to reach out to us and I'll make sure I get the right person on the phone. And at the end of the day too, when you meet attorneys, no one attorney is going to know all the answers to every question that you have. And that's why we act as a team. And that's why the part of this whole Venture Cafe, thing is for you to experience the different areas. Like I stay in my lane. I am not going to start talking to you about corporate stuff. I know enough to say, yeah, you need to talk to one of our corporate people. You start asking me what type of corporation to form. And it's just like, I know there's probably a special type you should form, but I can't tell you which ones because there's a whole series of questions you get asked and so on and what you want to do in the future. But it's all about that team approach. So if you have any questions, please feel free to reach out to either me or Joe, and we can set up, as I said, a gratis call with either with just us or with somebody else at our firm that really does that kind of work all day long, all the time, and to help you really kind of get the answers to your questions. Was there another one?
We got another one.
Okay.
It's asking, how might companies like the Stanford D School handle the IP created by their students while in their program?
Excellent question. Excellent question. And a company got burnt this way many years ago. So what they do is when you're a student or when you work on these things, these companies, these universities should be savvy enough now to know to have you sign one of these agreements. What that basically says, even if you're a student, like we have some kind of collaboration because we do work with some universities where they have these invention pods and so on. And so those things become a big deal. And they have like, one of our partners actually gets involved with the university more on the Pittsburgh and the state and actually teaching these things and helping to do these, to make sure that their checks and balances. But many years ago, there was a summer intern that worked at a company and that they thought, well, this is a summer intern, we don't need to have them sign an IP clause. They weren't thinking about that kind of stuff. Now companies have the janitors and everything, it's like standard in your employment clause, whether it ends up pertaining or not, arguably if a janitor knocks over a couple chemicals and creates something new that makes stuff, I can argue that you did it under your employment and like that should be something that we could pursue. But usually what happens is companies are savvy enough now or should be savvy enough that goes back to the employment agreement piece. And when you're dealing with students, right, to make sure that there's this discussion up front, because there's actually students that I mentor all the time that come to me and they're like, well, we've come up with this idea. And it's just like, all right, we need to talk and you need to start to put these things, in place. And so there are different little tricks and things you could do like on both sides, but it really depends. So a university may say, well, if you're going to participate in our specific invention program where your invention could go somewhere else, you need to sign these agreements. As opposed to you just kind of doing it on your own because you learned something special about intellectual property law in a class. I hope that answered your question. You have another?
Yeah, I have two questions. So just kind of clarifying on the trade, like the service mark and the trademark. So your business has to be like established and running for a little bit before you can apply, or?
No, it has to, well, you have to, so as Joe said, you can have an intent to use.
Okay.
So the difference between a trademark and a service mark is a trademark usually relates to a product, right? I'm going to call these glasses Fendi, like Fendi is the trademark that's these aren't Fendis, these are dollar stores. But anyway, so as opposed to, I'm a programmer, I'm a computer programmer, which you guys know I'm not. And I am putting out my services as a consulting. And so I'm calling it Marilou Watson or the Watson Code or something like that. I come up with a catchy name. That's my service mark, right?
It's already been used.
So it's, I'm sorry?
I said it's already been used by IBM.
Oh, that's they stole my name. Oh my goodness, I have to look them up. Thank you for that. So anyway, so that's the difference between a trademark and a service mark. A trademark usually relates to an actual product, a tangible product, and a service mark relates to a service. Did I answer your question? Oh, and then the intent to use piece. So say you plan to start up your consulting business, that's when you would use, so I come up with Watson Code. I'm just using it because I'm not trying to infringe it and stuff, but that's my last name. I come up with the Watson Code. I would use a superscript SM after that to show that I am trying to claim common law trademark rights in that mark because I intend to use it. But the smart thing for me to do is to file a trademark application as an intent to use, even though I haven't started my business yet. But similar to what was said is that, you want to do searching and stuff. You don't have to do a search. And I tell people this, either in the patent or the trademark world, you are not required to do a search. But I tell people all the time, it is like an insurance policy. Because at the end of the day, you don't want to throw good money after bad. And again, I understand when you're an entrepreneur, you're like, I got these pennies over here and then those pennies over there. I'm going to use them for this and that and so on. Those pennies will be well spent on intellectual property aspects. And the last example I'll give you was that someone, and the other thing too, is when you speak to an attorney, whether it's IP attorney or any kind of attorney, whether you hire that attorney or not, your discussions with them are bound, we're bound by the attorney-client privilege. So if you called me with a very specific question and so on and so forth, and any attorney, whether it's us or some other attorney, should first of all run a conflict check to determine that they don't represent the people you're trying to like sue, first of all, or you're trying to like maybe get involved with their product. That's the first thing. But secondly, when we have conversations, we're protected by the attorney-client privilege, even if you don't hire us. And I just like people to know that because people are afraid to tell what their invention is. So I like to tell people that up front. But the reason I tell you that is someone came to me about an invention, but you'll see why I can tell you when I finish the story. But normally I would not disclose what that discussion was if there was a potential patentable subject matter. So someone came to me about a detachable bed skirt. You know, bed skirts are the things you gotta like flip your mattress up, throw it down like it's a sheet, and it has the flounces that come down and it looks like ornamental. Nobody uses them anymore, but that's, you know, not too many people use them. But anyway, someone came to me about an idea of a detachable bed skirt. And I was like, man, that's a great idea because that's really a pain in the neck to kind of change these things out. And here's another thing. He's like, I did a search. I don't see it on Amazon. I don't see it on the internet. The internet is not the end all be all of the world. And you just don't know. And in fact, you don't know who might have filed a patent application to it, may even have an application granted as a patent, but they just didn't have the money to monetize their invention, or they hadn't started monetizing it yet. So you don't know, just because you don't see it out there doesn't mean it doesn't exist. So just like while we were talking, I went on the patent website and I just like used a couple of key terms and what came up, but an invention, a patent that was issued 2 months before he called me to a detachable bed skirt. That's why I can tell you the story, because it was already patented. And so, so his idea, a great one, clearly, because it could have been patentable, but he didn't pursue it first. And that's when Joe was saying too, that US and most countries, or I think every country is first to file. They want to reward people to pursue their inventions. You know, I hear a lot of people talk, oh, I've been thinking about this for 10 years and I finally decided I wanted to come and see if I can get a patent. And it's just like, okay, 10 years, okay. So anyway, I just wanted to throw those things out as well.
Yeah, and also have one more question. So what if you come up with like a business idea yourself, right? Mm-hmm. And you start wanting help and you kind of like meet somebody and you talking and you kind of want them to be in the business. So do you, before you even start, like, do you like get an NDA or? Okay, gotcha.
Yep. And the only caveat to that is if you've already formed a partnership with them, it's presumed that if you're within the same, if you and I are partners and we're in the same business, then it's okay for us to like talk. But before you start having those conversations, you just tell people like, I know you're my best friend, but you know, I need you to sign this before I can I want to pull you in on something. Those pain in the neck attorneys I have tell me that this is what we need to do. And I actually had a friend that did that recently, actually with her boyfriend and some of his friends, and she had an idea, which was a curriculum that she had written. So it's kind of interesting. And she happened to call me and I was just like, get the NDAs in place.
Does that apply to common law partnerships as well?
I don't know the answer to that. The answer is that it depends. Because again, right? Well, no, and like think about it. You talk about stuff like common law marriage, right? It's just like, how do you assess a common law marriage if that state provides for it, right? And so it's kind of like what's happened between us, you know, like, and I'm not really sure what a common law corporate business is. I don't know that I've heard of a common law business necessarily. Are you just saying you and I just start working together?
Yeah,
that what
more or
you're
less, but I talked to one attorney in the corporate space and they said, well, the moment you two started to get together about an idea, you had a common law partnership.
Yeah,
Right.
that's
So
not
it
my
wasn't-
area,
yeah,
and
but I
so,
was-
right,
Yeah,
that's not my area, and I don't even want to say yes, no, maybe, because that's like, but it could be, well, it depends, right?
Yeah.
Because I need to know what the structure of a common law partnership is.
Okay.
And it's kind of like I was going down the road of a common law marriage, right? So it's
Yeah.
like, well, do I have rights? We weren't married in law, but I think we were common law married. Well, first of all, does that state recognize it? And that could be very specific to a state.
Mm.
Like there may be some states that don't recognize this common law partnership thing. And again, I'm way out, I'm out in deep waters right now.
Food for thought.
So, yeah, I'll let you talk to one of our corporate guys,
There's a stipulation like if you live together for 7 years without being legally married, or if I can have proof of residency for at least a year, like if y'all bought a house together.
Yeah, there are actually specific requirements to
Yeah.
show that with cohabitation, but for marriage, but that's the whole point. If there are specific requirements to show some like common law partnership,
Mhm.
you would need to meet those aspects of it, similar to what you're saying. You had a question?
Not so much a question as a comment. As a contractor, I would like to point out is the longer the non-disclosure agreement, the higher my price.
Yeah, well, that's it. That's it. You name your price for whatever your reason may be.
I had a question about patents. You mentioned if it's disclosed, it's not patentable. So if I find a patent out there that's been, accepted, and then I see that the company has a blog post from like 2 years before it was, filed, do I hire an attorney to sue the company, or do I alert the U.S. Patent Office? How do I get?
So this could be a very specific scenario, it sounds. And what I would say is, it depends, because it really depends on how much what you're saying you found reads on their claims. Because just as a last point, intellectual property, I equated a lot of times like real property, right? You own, like say a house, you own a house and the property around it, right? Your boundary lines, the meets and bounds of your property is what's owned by you, right? So in a patent, in a similar way, your claims are your property line in your invention. And so the question becomes, while there may be general disclosures in the patent application, and something was put out 2 years prior that wasn't picked up by the patent office or whatever, you might be thinking like, hey, your thing's invalid because this was out beforehand. It depends, because it depends on what the ultimate claims ended up being. So what happens is that as you prosecute these cases, you go back and forth. It's like a tennis match with the patent office, and it goes to an examiner. I say you don't have to do a search because the examiner is going to do a search. But again, if you got a lot of money and stakes on this, you might want to do some searching to see what's out there and what's been put out there before. But the examiner will go back and forth and may say, but these claims are rejected because of this out there. And it's our job to kind of argue the distinction between these claims and what that is out there, if we can. If we can't, if it's dead on, then I go back to the client and say, listen, this aspect was rejected. The most you're gonna get is this out of here, or we can do this or do that. So it depends. So say at the end of the day, what ended up getting rejected was based upon what was disclosed 2 years prior, but I still am able to get something out of those claims. Those claims may still be good. And if a patent gets issued, the claims and the patent is presumed valid until proven invalid.
Right, so if I want to prove it invalid, is that something I need to hire an attorney for? Or is
Yeah,
it more
usually,
like-
yeah.
Can be complicated, right?
It can be complicated and yeah,
Is the attorney going after the patent owner, or are they going to the US?
it depends.
It depends.
Well, there are a couple of mechanisms you're talking about to invalidate a patent, right? So
Yeah.
there's a couple of ways to do that. One is go with the USPTO. USPTO have a committee that review the patent, right? There's a couple of mechanisms that can do that, but that has a time frame there. If you already miss that time frame, then you cannot do that through that way.
Yeah, but again, you can reach out and have a conversation.
Yeah, I was just gonna say on that note, we are wrapped up with today's session. This was absolutely amazing. For all the founders in the room, you know, like Marilou said earlier, like sometimes when picking up on the phone to an attorney, we feel like we might be like lighting money on fire, but in reality, it's the best money you could spend for your business to protect it properly. So the fact that Joe and Marilou are offering free time to sit down and talk to them for your business. Initially. Thank you for that caveat. Initially, absolutely take them up on it because their time is money and it's worth your effort to do this as well. So thank you so much for leading this session today. Like, this was really wonderful.